Welcome back to another episode where best-selling author and trial lawyer Shane Reed shares his best tips, tricks, and insights to becoming a better trial lawyer. This is episode 2 of 3, which means if you haven't seen the previous episodes, then we got to catch you up to speed, so I'll provide links to those previous episodes down below in the description for you to check out. And as always, links to resources, Shane's books, and Shane's website so you can reach out to him will be provided in the description below. And finally, if you find yourself enjoying this video, then be sure to hit the like button down below. Doing so helps keep the YouTube algorithm happy, which allows us to rank higher, to reach more people, and ultimately help more people. That's always the goal. But with all of that out of the way, I hope you enjoy this episode with Shane Reed. Let's maybe transition to another topic because you obviously have a lot of knowledge about a lot of different things, and opening statements are what I'm most interested in, especially because I went on your website, winatpersuasion.com, link down below to check it out. And one of your lessons that you have there is titled Opening Statements That Win Every Time. That caught my attention because I feel like everyone talks about closing argument, how great closing argument is, and the opening statement is the neglected child in the entire family. But then I read your website, there's a blog post, it says closing arguments are overrated. So can you explain kind of your thought process here, your philosophy?
Opening statements are the most important part of a trial. And the reason for that is there was a study done maybe about 30 years ago, so it's been out a while. And it found out that 80% of jurors make up their minds about a case after opening statements. So this idea that you're going to wait till closing argument to tie everything together and explain your case is just a myth that should no longer exist. And we don't need that study, Jarrett, to know that human beings, we all make up our minds a lot quicker than the judge's instruction, which is to wait until the end of the case to decide who's right and wrong. Mm-hmm. So with knowing the human nature of this study, I don't know why all lawyers aren't spending all their time on opening statement instead of just kind of half doing it and then putting all their effort into closing argument, because the jurors have made up their minds, at least 80% of them, after opening statement. So that's where your investment of resources should be.
And how much time are you spending preparing for opening statement compared to any other portion of trial?
I start my opening statement preparation literally as soon as I get the case. Wow. And I'm trying to think about what is my theme and why should I win? And as I'm going through discovery, I'm trying to put in those pieces of the puzzle to my theme. I might change my theme, but I'm building a story. And if you were talk about the week before trial, when everyone's running around with witness schedules and all these other distractions, I am focused on practicing the content and delivery of my opening statement. I would say almost 80 to 90% of the time, that's where my effort is. Wow. Because I know how important it is. And the other 20% is on the witness preparation. And during that time, I'm using that to help build my opening statement. So it's all about getting out of the gates quickly, because as most lawyers, I hope, by the time you get ready for trial, that week before trial, you're pretty much ready to go. So that last week should really be about fine tuning and focusing on what's important. And that's the opening statement and not a lot of other distractions that we all get faced with.
Okay, so other than maybe withholding some key information during opening, when they should probably mention that up front, what other things should lawyers keep in mind with their opening statement?
I guess there are two big mistakes. One is failing to address the weaknesses in your case, which you just mentioned, because then you'll lose all the credibility if I finish an opening statement and the other side gets up and goes, ladies and gentlemen, I had this opening statement prepared. I'm going to throw that away. I'm going to talk about what Shane Reed didn't want you to hear. And that is blah, blah, blah. Now I've lost all my credibility. I'm sweating bullets and the trial is over, because once you lose your credibility, you cannot get it back. The other mistake attorneys do is they overstate and overpromise what they can deliver. So if I was going to say, I'm going to prove to you these three things, what is the other side going to do at closing? You heard Mr. Reed in opening statement say he was going to prove to you three things. Well, you know what? He only proved one thing, and he didn't even prove that very well. So now I've lost credibility again. Mm-hmm. And if you're not the truth teller in the courtroom, you're not going to be rewarded. So two things, overstating what you're going to prove, and secondly, not addressing your weaknesses are the two main things I think lawyers do wrong.
And how complex is your opening statement? Let's say we have a case with experts and we, have a theme, we have anticipated arguments from the other side. How into the weeds do you think lawyers should be getting with their opening statement? Or do you think it's all top level stuff?
I believe it should almost all be top level stuff. I like to focus on the rule of three. I'm going to talk about the three main things we're going to prove at trial. Mm-hmm. Keep it simple, persuasive, powerful. The caveat would be is if you have a complex trial and maybe you have an hour and 15 minutes for your opening statement for a 6-week trial, it would make sense to begin teaching the jurors what some of the weeds are so that when they see witnesses, there's a framework for it. Mm-hmm. But I would never get into the weeds much at all. Mm-hmm. But providing them a roadmap, you're going to hear from this expert. He's going to explain to you a few terms. Let me just tell you about them now because you're going to hear them throughout the trial. I think something like that where you're teaching is fine. You're providing framework. But in general, it is big picture, 3 points, start strong, end strong, address your weakness. If you do that, you're better than 99% of the lawyers in the courtrooms today.
Yeah, I was watching the Mark Lanier Johnson & Johnson opening statement, which talk about a complex case from what I saw as an outsider looking in. And his opening statement seemed to simplify things, but then on the back end, he was like trying to establish himself as an expert on these topics, not outrightly, but he was just getting so into the weeds about here's how it goes into your lungs, and here's how it looks on if you really look at it at a microscopic level, and why once it's in your body it can't get out. And as he's talking, you're like, man, he knows his stuff. He's really establishing himself, and establishing that credibility. But he was balancing it. Have you seen that opening statement by chance?
I have seen it. I've interviewed him about it and talked to him about it, and know Mark Lanier very well. Mm-hmm. I think he's one of the best at presenting complicated information in an easy to digest format for jurors. And that's why he has all of these success with these record-setting verdicts. He's got a roadmap. He tells them the points he's going to make. He never over-promises. Mm-hmm. And he thinks of opening statements as presentations where it's a teaching opportunity, not in a dull way, but here are the big ideas. And here's some more details about some ideas you might not have heard about, which is how asbestos can cause cancer. And I'm going to touch on that so that you look at me as someone who can help you be detectives, which is a word he uses in the trial, and find out how to bring the defendant to justice. So I think you're right. He does both of those. I think he does them almost like no one else does.
And he broke the concept down very simply. I can't remember what it was. Do you remember by chance?
He had a couple of different things. One, which I remembered, was his bottom line message, which I'm a big believer in. What is one sentence that summarizes what your case is all about? And it's a powerful sentence. It's something easy to remember. For this 6-week trial, for 22 women who had ovarian cancer, he had a slide with Scrabble tiles that had A, B, C on it. And then there's an equation, A plus B equals C. And his bottom line message was asbestos breathed in equals cancer. He told the jurors, he said, this case is that simple. If I can prove asbestos was in the Johnson & Johnson baby powder, I will win. Very simple. They're going to remember those Scrabble tiles. Anyone can remember A, B, C. And in contrast, when the defendant attorney spoke for an hour and a half, you couldn't figure out what his bottom line message was. It should have been, there is no asbestos in the Johnson & Johnson baby powder, right? If he wants to win that case, that's his simple message. But he went on and on about everything else. And Mark Lanier comes out looking like the knight in shining armor. He's got the simple message. He says, I'll prove it to you. And the defense attorney does not have a simple message. And you're thinking, well, maybe there is asbestos in the baby powder.
I just starred what you said about the one sentence. I've never heard anyone put it that way. The only type of training or exposure to just like trying to simplify the case to someone is always like, have those rhymes, those cute little rhymes, if the glove don't fit, you must acquit or something like that. But having the ABCs or something just so simplified seems it seems difficult, honestly, simplifying a case all the way down to one sentence, but also it seems powerful at the same time.
It is difficult and it takes time, but it makes all the difference. So that investment in your time, it'll tell you, Jarrett, what depositions to take. If you know in one sentence what your case is all about, you won't get distracted by the thousands of documents and all the defenses. You'll just hone in on, was there asbestos in the baby powder? And if that is your one sentence for that particular case, you're like a laser trying to find out that information. But it does take time to make it persuasive. It takes time. Very few people do it because it takes time, but they also don't realize the payoff for it because it's persuasive and it's something the jurors remember, and it's something that motivates them to return a big verdict, or on the defense side to shut down a plaintiff who's got a frivolous claim, when that one sentence just goes right to the heart of why the plaintiff has misdirected anger and whatever it might be. So
I'm seeing everything come together right now. Like all the puzzle pieces are starting to fit to where, and correct me if I'm wrong, whenever you are receiving a new case, from the very beginning, you're thinking, what is this opening statement going to be? And then whenever you're thinking about what this opening statement is going to be, it's like, what is this one sentence really going to be? And then once you figure that out, or you start to get a feel for it, that's what you are focusing your entire discovery process, depositions, and everything moving forward past that. Is that right?
That's right. And this isn't just Shane's idea, but great lawyers such as Lisa Blatt, she's a woman with the most oral arguments before the United States Supreme Court, 35 and counting. She told me when I interviewed her for one of my books, she said, the first thing I do when I get a case is I think about, what is my theme and why should I win? So great lawyers are kind of all approaching in a different way. And I just came up with this idea of the bottom line message, this one sentence that has a human truth on why you should win. And it doesn't work just for Shane. It's worked for a lot of really good trial lawyers. It's a proven principle that everyone ought to try.
And what is your routine for gearing up to present your opening statement? How are you preparing? Are you doing your own mock opening statements in front of someone?
I do that. I guess it depends on the case. The way I prepared is I write it out once.
Okay.
And it's going to be a bad draft, but I just want to get it started. I go, I know that's not so good. And then I throw it away. And from then on, it's just an oral recitation, and it'll change. You probably won't recognize the final opening from what that first draft was. And when I rehearse it orally, the reason I do that, I want to internalize it so it becomes a conversation. Jared, if I get a good idea when I'm out walking the dog or in my house, I'll write that down when I get home and write down a key phrase. I really phrased that well, so I can remember it. But the more you speak it orally, whether it's a formal mock, I'm not sure what a formal mock trial presentation, or just to yourself, the more you do that, the more it becomes internalized. So when you stand up in court, you're without notes, you're speaking from your heart, you're having a conversation. And by doing that, the juries relate to you, and you'll feel very relaxed that, okay, I remember my 3 ideas. I don't need to have these memorized words that I'll probably forget, which escalates into a multitude of problems.
So one thing I learned through, I think it was moot court more so than mock trial in law school, was the fear of the unknown, not knowing what a judge was going to ask me if I had a hot bench, and being afraid of how I was going to handle that situation. And what I realized was the preparation of having that bare bones outline as a home base to always go back to if I was ever, taken off that script, or if I was ever distracted, or if I ever had a moment of pause. It's let's just go back to home base. And then once you're back on home base, that's your comfort level. You're back there. Is that kind of what you end up doing once you've recited it enough?
Yes. And then one of my tricks is if I'm at a jury trial,
Mm-hmm.
at counsel table next to a glass of water, I'll have a topic outline, no more than 15 words on it, big print. And during my opening statement, I'll go to my table, I'll get some water. I'm looking at the outline as I get the sip of water, and the jury has no idea that I'm checking my notes. And I'll look to see if I've forgotten to say anything. And that's my crutch. And then I go back, and it takes about 10 seconds. No one knows what's going on other than I'm thirsty. But it gives me this aura of, wow, he's really speaking from his heart. He's not using notes. But my crutch is there, and it works perfectly. And same thing if I was at an oral argument or a hearing, I'm not going to take up notes to the podium. If anything, I will put an outline up there at the podium before the judge walks out there, so he sees me or she sees me walking up without notes. And if I'm going second, I'll just keep my outline at my table, and that's my crutch, and I probably won't need water, but it's there. If I need it, I can know who's going to accuse you of not, being wrong for getting thirsty and getting a sip of water. No one is, but it gives you that confidence. And I think it's very impressive to the people listening that you don't do it with notes.
I'm grinning from ear to ear right now hearing that, because it takes confidence to do what you just said. Because if you're stopping your presentation and just walking over to the table to get a sip of water, that silence is going to grab everyone's attention. So, I'm willing to bet that the next words out of your mouth will probably be the most honed in phrase that you're going to say. And I think that even if you don't lose track or anything, just working that into the opening statement at some point and just having just that hard hitting line right after would be great.
Right. So I think, so the pause is not so dramatic that people go get your water and get on with it. So as I'm talking, I will be walking over to the table, and then, there's the pause as long as it takes me to get the sip of water and look at my notes.
Yeah.
And then, you can be very dramatic, but I don't want your listeners or viewers to think, oh, Shane's taking 30 seconds of silence and there's this big break while he goes and refreshes himself, because I don't think that would be polite. So I am talking, I walk over as I'm talking. Then I do have to take a sip, and it gives me a chance to kind of resettle, and it probably takes 5-10 seconds. And then there is a nice pause to do something very dramatic after that.
So you're not displaying dominance by drinking the entire bottle in one go.
Exactly.
If I'm going to derail the conversation very, very briefly. So in moot court competitions, at some point when you're doing the intra-school competitions, you kind of are over it to some extent, and you're doing it over and over again. At some point, we were going against our friends. I went up to the moot court podium, did my whole presentation, had my paper in front of me, and then I felt like I knocked it out of the park. And so I turned, and I very, very sneakily showed what I had on there, and it was just no notes, empty page with a smiley face on it. And it was top that, guys. But it was friendly.
Perfect.
It was all friendly. But that being said, on the other end of the spectrum, when I'm not feeling myself, there are definitely times where I get the anxiety and legitimate fear with public speaking. So do you mind if we transition to that a little bit?
Sure.
Okay, so what I see a lot, especially on emails coming in through the Law Venture community, how do I overcome, as a lawyer, the fear of public speaking?
Eyes are on us, and we immediately turn into this fight or flight syndrome. And we've all heard of it, but it's kind of good to know why it happens. There are a couple of ways to overcome it. First, just be aware that, hey, I'm nervous. That's natural. And now I'm gonna get through the door of nervousness to the other side where I can be persuasive.